Good morning, everyone. Good morning and welcome to the first parallel session of the second day of our event. So the first parallel session of today is about two main concepts. One of them is economic resilience, and the other one is, as you can guess, national security. My name is Ugur Hekim. I'm a legal practitioner. I'm based in Brussels, practicing international trade, and I will be the moderator of the session. So let me have a brief introduction of our panel. What are we going to talk about today? So over the past years, we have seen that these two concepts, economic resilience and national security, have moved from the margins to the center of international economic governance. And what used to be framed as something temporary or exceptional is now becoming countries' long-term policy tools. In some cases, they're even giving shape to new legal norms. But this shift, as our panelists will elaborate today, is not unfolding the same way everywhere. What economic security means to somebody in Brussels or Washington is not the same as Bogota or Sao Paulo. And as we are witnessing recently, what seems to be the new normal, the growing use of national security justifications around the world, this issue raises serious questions in our practice. How consistent these moves are with international law, how they reflect or reinforce global power imbalances, and what do they really mean for the future direction of the system as a whole? So in this panel, we're going to be talking about this, understanding this shift and its consequences, and how it plays differently across different regions and sectors. We begin with Diana, a practitioner and a lecturer at Universidad Externado de Colombia. With degrees from both Colombia and the UK, Diana's work bridges public and private law together. She's working on international investment, arbitration, and the right to food. Today, she will examine how food security in Latin America is increasingly treated as a matter of national security, especially in light of unequal access to land, weak institutional protections, and the growing influence of foreign capital. Next, we have Natália. Natália is an assistant professor at the Federal University of Sao Paulo. She holds a double PhD in international economic law from Maastricht University and University of Sao Paulo. Together with Diana, they actually co-direct the Latin American Network of International Economic Law. And today, she will take us into the mysterious world of minerals, critical minerals, and the energy transition. And she will explore how domestic mining and energy transition policies in what we call resource-rich countries in the global south, specifically Argentina, Brazil, and Chile, will shape or is shaping at the moment their international engagements with advanced economies to secure their mineral supply chains. And our third speaker, Tim, will bring a completely different perspective to the discussion. He is a PhD researcher at the European University Institute in Florence, where he also serves as assistant editor of the Journal of International Economic Law. Tim's work focuses on investment screening and outbound controls, particularly in Europe. After having graduated from the University of Passau in Germany, he has done traineeships in DG Trade at the European Commission and other internships in international law firms. Tim today will explore how technological competition, which is at the core of our discussion today, has reshaped what we think of as technology transfer and how national security measures, if implemented or designed in the wrong way, or if not carefully designed, so to say, can end up creating new types of imbalances around the world. And finally, we're joined by Professor Henry Gao, a leading global expert on WTO law and China's role in the global trading system. Henry is a professor at Singapore Management University and senior fellow at CIGI. As he continues to advise international organizations and governments in the meanwhile. He will speak to the important question, the elephant in the room, some call, which is when can trade wars be good? He will focus on, of course, the US-China trade conflict as a starting point, and he will reflect on how these tensions have exposed weaknesses in the WTO and pushed us to rethink how it works or it doesn't. After this first round of interventions, we will open things up with a Q&A session. We will also invite you to ask your questions. If time allows, we will dig into some other themes such as who defines resilience and security and who pays this price, whether security exceptions are rule breakers or rule makers, and finally, the impact of strategic competition. With that, let's begin. Diana, the floor is yours. Thank you.
Ugur, good morning, everyone. My name is María Beltrán. I'm from Universidad, Externado de Colombia. And in the presentation that I'm going to do for the next 10 minutes is about food security and national security in Latin America's international economic law landscape. The reason why this topic, I consider it's important, it's because there have been discussions in the region regarding how food security starts to be an issue when we are talking about international economic regulation. So to begin very briefly, I'm not going to detail on the definitions of what we understand by national security or food security, but mainly on the relationship that exists between these two concepts. Basically, what we talk about when we talk about when we are mentioning food security is we are talking about a resource, and a resource that it's vital for any community. As a result, the fact that exists any sort of control over this resource implies questions regarding national security as well. When we talk about control and food, there are several elements that need to be taken into account, like what happens in the geopolitical leverage, the type of strategies that exist for nations to exchange this particular source, the control that exists over this source, and also the resilience that exists by the lack of this resource. In that sense, here what we can identify is certain potential threats that exist for both concepts in a particular context. Now, the control over the resource of food can be understood by two different ways, either by giving the food, like international aid, or by the domination of the resource as such. I'm going to focus on the latter, because the domination of the resource of food is what establishes the premise of how does the agricultural market and agricultural products work and the food market works in general. We live in a society that is export-oriented and agricultural systems are export-oriented. Therefore, the premise is that we have a value chain that favors the acquisition of food. In that sense, what happens in Latin America is that there has been a rise in the agro industry. This is the second part of my presentation. There is a rise of agro industry regarding certain types of crops. And this is a phenomenon that it's not exclusive from Latin America, but that has affected the system of agricultural products in Latin America. So the drivers of investment in Latin America has been or has been developed under the concept of flex crops phenomenon. Example of these are basically soy, palm oil, sugarcane, corn. And the characteristic is that these type of crops are not only for human consumption, they are also used for feed animals and for biofuels, which is very important. In the case of Colombia, for instance, what we find with the plantations of palm oil, sugar in a less representative manner is the demonstration of what happens with this particular phenomenon and what dictates the type of policies, of economical policies that are enhanced and enforced by the government. This also implies that there is a financialization of agriculture in general. Therefore, these are the type of products that receive not only certain types of subsidies that in Colombia are not that common, but also that receive the money to the development of projects that involve these type of crops by transnational corporations, investment funds, and state-owned enterprises. Even, and this is probably the most important actor in Latin America, interregional investment funds. An example of this is what happens with the Latin American Agribusiness Development Corporation, which is a fund that focuses on the production of certain types of crops in Colombia, Peru, Nicaragua, Ecuador, among others. So the fact that we have this environment has as a consequence several phenomena that I'm going to focus in three. First, land grabbing. Second, the discussion between production of monocultures and the production of local food security. And finally, the paradoxical sustainability effects. Regarding the first one, this is a social issue that has a vital relevance in Latin America due to the conflicts, the social and political conflicts that historically we have had. In Colombia, as you might know, this was a main point of discussion during the peace process. And and in other parts of the region, like what happens in Brazil, what happens as well in Argentina, in Central America, is that there is a disposition or better an exclusion of certain actors that are important for the production, not only of these flex crops, but also of the food that the community produces. Now, regarding the topic of the monoculture versus local food security, the main issue is that certain local systems for the production of local of local products that are important for the well-being of the population are left behind, and therefore it implies that there is a dependency on food from other that comes from other parts of the world or that are produced in a different scale on the value chain. And in a region like Latin America, where the production of food is not only vital, but we are able to produce like any sort of food, it's important to consider why are we sacrificing these local systems over monoculture that actually also has sustainability effects. And that leads me to the least part of the phenomena that this situation produces, and it's the paradoxical sustainability effect. Because on one hand, the policies focus on the production of food for exporting, right? But also the intent or the aim for sustainable projects in accordance to other types of international obligations. And nevertheless, we have social phenomena in which there is violence, there are crimes that affect that affect the environment and that affect the way in which we produce food for ourselves. In this scenario, and as the third part of my presentation, how is that the international economic law framework acts or it's present particularly? And we can analyze it either from the investment point of view or from the trade point of view. Regarding the first one, from the investment, what it's important to highlight is what happens with the regulatory chill effect. because of the amount of treaties that we find in the region, especially first, second generation, third generation treaties. States are cautious on the type of measures that they can adopt in order to guarantee the security of the people that, of the citizens and the people that live in the region, in order to protect their food security. Furthermore, if we go into the carve-outs that the treaties bring, you are not going to find something specifically that recognizes food security as part of them. Nevertheless, it's a conversation that I assume we are going to start to have at some point, specifically with the type of projects that we are seeing in the region. Particularly, we have to highlight what happens with expropriatory clauses in this type of treaties and land owning restriction policies that every state is implementing right now. We find this specifically in Argentina, Brazil, Peru, and I'm bringing the example of Colombia, as recently there was a decree by the national government that justified the expropriation of certain types of land based on the guarantee of the right to food and food security. Even though the decree has many defects, the thing is that this opens the door precisely to a debate on how do we understand food security, and especially in a fragmented system like economic international law is, and how states are going to face not only the phenomenon of regulatory chill, but also the obligations that they have internationally regarding something like its right to food. Now, on the matter of trade, we can find some silver linings in contrast of what happens with the investment law. Besides from the application of the Agreement of Agriculture that Latin American members of the WTO have been using for several years, and that they have been active on the disputes that have been presented, regional trade agreements have become vital to recognize the right to food as a matter of national security, even though it's not as expressed as I have been explaining right now. And the reason for that is because one of the objectives that have been identified in the last couple of years is that there is, and especially after COVID, is the need to have internal markets that supply to the region all the food that they might need, or that the citizens and the people that live in the region might need, without depending on a bigger value chain that it's so weak as we have seen during the pandemic. An example of this is what happens in Mercosur, and specifically in the Pacific Alliance Treaty, where certain key features of the agricultural provisions include tariff elimination on most agricultural products, rules of origin specific to agricultural commodities, sanitary and phytosanitary harmonization, trade facilitation measures for perishable goods. In that sense, how can we understand this problem that we face in investment and in trade in order to recognize the need to have the control over the resource of food? And a possible answer is, how do we incorporate the interpretation of the right to food into this particular conversation? As the developments on the right to food include the recognition of subjects in the value chain, such as peasants, rural workers, and the establishment of inclusive policies. Also, by the interpretation of right to food, we can recognize environmental, cultural rights, depending on the topic that we are talking, something that is more related with food sovereignty than food security, but that's something to take into account. Therefore, I don't think it's important, and as a conclusion, I don't think it's necessary right now that because to have topic of food security as specific and expressed in this type of treaties, but we can interpret it from the general security issues that we can find, like what happens with Article 20, even Article 21, even though it's a little bit more complicated. But the recognition that food security, it's a matter of national security, it's vital, especially in a moment of resilience like the one that we live in Latin America. Thank you.
Hi everyone, my name is Natália Figueiredo. First of all, I'm very sorry for my voice. It's a result of two flights totaling 24 hours under extreme air conditioner. But let's go back to the panel. Well, I believe that one of the goals of this panel is to shed light to the fact that emerging markets and advanced economies have different approaches in relation to concepts such as energy transition and economic security, and national security and economic resilience. So I take the framing of this panel as an acknowledgement that these concepts, they are not fixed, and that they actually vary depending on who's speaking, from where, and with what purpose. And that's the starting point of my presentation today. But let me briefly outline the scope of my research, the hypothesis that guides it, and why I believe this work is relevant. First, my research investigates how the domestic governance in critical minerals of emerging markets shape the way these countries engage internationally. My focus is on Brazil, Chile, and Argentina, as I come from Latin America. And my specific goal is to analyze how the differences in their energy transition and critical mineral policies, they affect the type of international frameworks they enter into with advanced economies. My hypothesis is that countries, mineral-rich countries that have a more integrated and institutionally robust policies, they are in a better position to negotiate agreements that go beyond access and investment facilitation, and that can actually include more balanced terms in relation to transfer of technology, value addition, environmental safeguards, and mutual benefits. And why I believe that this research is important, because we have seen an increasing number of international instruments that are designed to secure minerals in the name of economic resilience, in the name of national security for advanced economies. But we rarely examine how the mineral producing countries generate emerging markets. They shape the terms of these agreements and the distribution of power within them. And that's the dimension I want to bring to the forefront. But it's important to highlight that concepts such as critical minerals, economic resilience, economic security, they vary, as we mentioned, according to whom is speaking. And critical minerals, for instance, for advanced economy may mean those minerals that are important to sectors such as clean technologies, digital infrastructure, and defense. But for emerging economies, for instance, critical minerals may have a different meaning. They may mean those minerals that are strategic for export earnings, for industrial development, or even for totally different key segments like agriculture. And to analyze all these differences, I draw on the concept of regime complex as articulated by an Indian researcher named Nidhi Srivastava that I had the pleasure to engage in one of SIEL conversation. And this concept reveals that the global governance of critical minerals doesn't rest on a single institution. It sits across the intersection of trade, investment, energy, environmental law, labor rights, human rights, with often overlapping and conflicting goals. So the focus of my research is to analyze how the critical mineral policies in the global south interact with this fragmented landscape. I ask what happens when countries with different visions of critical minerals, energy transition, economic security, economic resilience, they enter into agreements with advanced economies seeking to secure the supply of minerals. And two background dynamics are important here. First, there's a clear power imbalance in the global governance of critical minerals. Why? Because generally consuming countries are those countries that write the rules on trade, investments, and critical mineral chains. For example, the US, EU jurisdictions, and China, although China is also an important mineral supplier. And emerging markets, which are generally resource-rich countries, they are relegated to a position where they are supposed to liberalize export guarantee access without parallel commitments on value addition, technology transfer, and so on. And the US-led Mineral Security Partnership is a good example of that because it's originally designed to secure critical minerals to the US and its allies. And while mineral-producing countries like Zambia and Argentina are relegated to a consultative forum. The second background dynamic that is important is that there is a growing literature, especially from the Global South, that criticizes the narrow technical economic notion of energy transition. We have authors like Maristela Svampa in Argentina, Bruno Bringel in Brazil. We have also El Quintral, which is a Chilean collective of activists that critiques extractivist energy models. What all these authors claim is that what we need is not a narrow vision of energy transition that is focused on changing energy matrices, but we need a real energy transformation that involves a real change in the way that we produce, we consume, we move, and we relate to nature. So from the perspective of this race for critical minerals, this means that we risk reproducing extractivist models where developing countries, they are relegated as, or they are stuck as exporters of raw materials and as sacrifice zones in facing disproportionate environmental and social burdens. So with this context in mind, I analyzed the energy transition and mining policies of Brazil, Chile, and Argentina, which are key or central to the global supply of lithium and other critical minerals to the world. And I wanted to analyze the difference between these policies. And then I looked at the way that these countries engage internationally in the area of critical minerals. Let me begin from the domestic side. I made this chart, but we will not have time to go through it, so I go to a more concise version to show the main differences between the policies of Chile, Argentina, and Brazil. What happens is that Chile stands out. It has a state-led long-term strategy. Its mining policy is integrated with climate goals, industrial upgrading, and regional development. Its state-owned companies like Codelco and Enami are active not only on the extraction of minerals, but also in policy implementation. Chile has a progressive fiscal regime where lithium royalties are linked to lithium prices and they are reinvested in R&D and sustainability. And it has the most institutionalized environmental and social guards among the three countries. Brazil, in turn, has a more fragmented and market-driven approach. Although it has formal instruments in place, such a list defining what is strategic materials and also some financing tools in place, policy implementation is weak. State plays mostly supportive role and private actors actually dominate the scene. Brazil lacks a strong mining company. Its former flagship Vale was privatized in the 90s, and although it's still subject to governmental influence, it lacks a public mandate. Also, Brazil has one of the lowest royal rates of the region. It has a weak environmental governance and little policy integration among mining and energy transition or decarbonization goals. Argentina finally has a federal and decentralized model. Provinces control mineral resources, and although national government seeks coordination, it lacks capacity or it has limited influence. Argentina policy focus on attracting investment, particularly in lithium, but the state has limited capacity for value addition and fiscal capture. Environmental oversight varies widely across provinces, and while public participation is recognized, it's applied inconsistently. So that's the main differences between these countries' policies in terms of mining and energy transition. Then what I did was I mapped all the relevant instruments they signed in the past 3 years in the area of critical minerals, governance instruments, and also instruments involving state-owned companies and state-aligned actors. And we have these results here regarding the instruments that these countries signed. In summary, we see that Argentina and Chile, they have engaged in several MOUs with jurisdictions such as the European countries, the US, and others. While Brazil has engaged from a more, let's say, collective perspective. It has participated in a multilateral initiative, the UN Critical Minerals Panel, as did Chile. And Brazil was also politically involved in concluding the FTA between Mercosur and the European Union, which, although it's not exclusively regarding critical minerals, it touches upon it. Well, my research is still in progress, and I'm still analyzing all these instruments and the contents of it. And there's also a challenge because none of them are publicly available, and I have to request information under access to information legislation. But to understand how these national policies are reflected in these international agreements, I compared 2 comparable and publicly available documents, which is the MOU signed between Chile and the EU on critical minerals, and the MOU signed between Argentina and the EU on the same area. So the differences are telling. Why? Because in the Chile-EU MOU, the MOU uses more operational language. It talks, for example, about industrial upgrading, semi-finished products, domestic value addition. It also uses a stronger language on ESG commitments. It makes reference to Chilean policy language. It also includes reference to long-term political and economic benefits. In Argentina, the MOU uses more generic language on value addition and environmental standards, adopts EU-centric terminology, and it frames cooperation more around investment and competitiveness. So what does this mean? This MOU shows that international agreements are not made in a vacuum. They reflect each country's domestic institutions, priorities, and development models. Chile negotiates from a position of policy coherence and long-term strategy, embedding mining in a broader vision of decarbonization and development, while Argentina engaged through a more market-oriented, investment-focused approach and less institutional strength. To conclude, these differences shapes the kind of coordination possible and the potential for value creation, environmental governance, and national benefit. This comparison helps us identify how national policies shape international cooperation. It shows us where more nuanced and balanced frameworks can emerge, one that not only reflect the supply concerns of industrialized countries, but also incorporate the development goals of producer. It also points out to the need for plurilateral and regional mechanisms where resource-rich countries help define the rules and not just follow them. Thank you very much.
All right. Thank you. Thank you so much from my side as well. And thanks to the organizers for setting up this beautiful panel. I'm delighted to be on it and speaking a part of it. My paper that I'm currently working on, it focuses primarily on foreign investment screening mechanisms, particularly in Europe, both inbound and outbound. And I'm particularly interested in this notion of technology leakage that seems to be popping up in discussions around economic security more and more. And the puzzle that I'm trying to tackle is the following. Despite increasingly lagging behind, advanced economies emphasize technology leakage as one of the primary concerns to be addressed in economic security policies. And to unpack that a little bit, what I find is that underpinning this concern about technology leakage is the assumption of some sort of technological advantage, some say superiority, in a sort of global geopolitical competition. And at the same time, it also seems to be kind of a truism that Europe lags behind in many technological areas, which lead to calls for more competitiveness or technological sovereignty. And behind that are two legal questions that I want to address in the paper that I'm working on. Namely, how is technology leakage underpinning the legal frameworks of investment screening in Europe? And second, what are the implications for these legal frameworks if the levels of technological advancement shift in the sort of opposite direction? And what I try to do is propose some ideas for reinterpretation, as well as hopefully draw on a comparative study with Japan, where I'll be heading right after SIEL for 2-3 weeks as a research day. So hopefully more to come there. But first, let's go step by step. First, how is technology leakage underpinning the legal frameworks of investment screening in Europe? First, making a connection between technological advancement and a nation's prosperity is nothing new. Neither is linking it to national security. We've seen that from the beginning of FDI screening in the US with the Exxon Florio amendment, for instance. And for the EU foreign direct investment screening, let's also remind ourselves of the origins of the current 2019 regulation. I mean, after there were some concerns about sovereign wealth funds at the beginning of the 2010s, it was mainly attempted or takeovers by Chinese investors of European technology companies like Axitron, German semiconductor equipment firm, or KUKA, the German robotics firm. And these concerns, among others, got translated then into the 2019 EU regulation on FDI screening. In its Article 4, it says specifically that critical technologies, including AI, robotics, semiconductors, and many others, are factors to be taken into account when determining whether a foreign investment poses a potential risk to public order and security. However, also important to note, there's no EU screening. It's still a framework that allows member states to screen or just gives them as an option for now, no mandatory screening. Fast forward to 2023, and the European Commission publishes its economic security strategy for the first time, of which FDI screening is a core part of. And in the strategy, it explicitly holds that one of the 4 key concerns for European economic security is to prevent the leakage of sensitive emerging technologies. Now, beyond inbound FDI screening, we've also seen more focus on outbound investment screening, or at least concerns about outbound investment. After a white book in 2024, the Commission releases its 2025 recommendation on the monitoring of outbound investment, which is so far a very non-legally binding instrument, and it seems to be very far away from legislation so far. But it really exemplifies this kind of focus on technological leakage, as it recites the risks caused by technological leakage are likely to be particularly acute for a narrow set of technological advances that can enhance military and intelligence capabilities of actors that may use them to undermine international peace or security. And also the risk assessment that the monitoring scheme proposes to the member states relates specifically to the risk assessment should identify elements of risks and potential vulnerabilities regarding technological leakage as one of the main type of threats. So this is to show how this notion of technological leakage is underpinning the legal systems and the emerging legal systems. Let's go to the second part. What are the underlying assumptions in this notion? And to me, I identify 3, very oversimplified. First, there are certain technologies and know-how that are crucial for a state's national or economic security. Second assumption is that they can move alongside the goods or investments that to the other side of the economic transaction. And thus, if we restrict the cross-border transfer of these economic transactions, we also restrict the movement of technologies. In the paper, I will go in much more detail on this notion of technological competition between states, technological dependence, also techno-nationalism, and I also draw on technology transfer literature to question the kind of mechanisms how technology transfers actually happen. As well as the very over-dominant focus on north to south technology transfers. This literature seems to indicate that it's much more about the people and the know-how that are moving, that are actually creating these kind of very key transitions of technology, much more so than certain goods or blueprints or a USB flash drive. But today I want to focus on the third assumption that I'm identifying, namely more fundamentally that there is this assumption that there is something to leak. Something that, quote unquote, the other doesn't have and doesn't have yet, and that we don't want them to get from us. However, that strikes me because when I talk with people in the more tech world or researching technological innovation in Europe, I almost always get to see the opposite impression, namely that they're saying, Europe is lagging behind. All of the big technology companies are either US or Chinese. Yes, of course, they would say there are certain European hidden champions which do really produce unique world-leading products such as ASML in the Netherlands, Zeiss Optics in Germany, Trumpf lasers, for instance, or Zoatec in France. But that, grosso modo, Europe is lagging behind. So I got into this research a little bit more deeply, and I was looking into, are there any indicators which are reflected of that sort of mismatch? And if we look, for instance, at the WIPO Global Innovation Index, China is 11th across 133 economies today. In 2023, China surpassed the United States in total patent filings. And one thing that I want to really point out is the Australian Strategic Policy Institute's Critical Technology Tracker, a really insightful database that goes into many details that these critical technologies we are looking at in these securities researchers. And they find that for some of these technologies, all of the world's top 10 leading research institutions are based in China and are collectively generating 9 times more high impact research papers than the second most ranked country, which is usually the US. And like this study, it looks at research institutions, including companies. So Google, for instance, is #1 research institutions for natural language processing. And we can happily go into discussion about the methodology that they use. It's more taken on research impact. And of course, they also caveat that there's a difference between high impact research and the translation into economically viable companies. But still, I think it gives some indicators. Also, of course, we all know the anecdotes about DeepSeek versus ChatGPT or EV batteries, where China is one of the leading greenfield investors in Europe, particularly Hungary on EV batteries, at a time where Europe's Northvolt kind of hoped that domestic EV battery production has just filed for bankruptcy this year. So what are the implications? So first, I identified that there seems to be a partial mismatch between the legal frameworks and the technological reality. And so long as if one aims for coherence, one might want to narrow that incoherence down. And of course, while asymmetry still exists in some fields, these frameworks still presume the innovation originates exclusively from the global north, but this is not longer true. This also risks perpetuating global north to south structural inequalities. I mean, the argument that technology is supposed to be a common heritage of humankind is also not new. It's been part of the new international economic order proposals. Resolution 3201 of the General Assembly has one of its 6 core groups of claims is that the entitlement of developing countries to development assistance and to the transfer of financial resources and technology is one of the core elements. However, of course, one might argue these frameworks are supposed to do risk management. They're not about fairness. Their goal is to protect national interests and not about global equity. More. What are the proposals? Really briefly at the end. So first, I would propose to reinterpret the concept of technology transfer in a more bi-directional, context-sensitive approach, which focuses on the functionality and dual-use potential rather than the origin of the investor or the direction as a geopolitical proxy. For outbound investment, for instance, that might take into account the real differences in types of outbound investments that are happening, for instance, between the US to China and Europe to China. The best study I found so far is by Mathilde Villiers at the French Institute for International Relations, which has mapped these different types of investments and has found that they're structurally different. US investment into China is much more heavy on global, on venture capital, on creating impacts for how to run a business effectively, while Europe is more dominant about industries like Bosch, Siemens, so a very different kind of outbound investment. Secondly, you might want to go more beyond very static definitions of restricted technologies. If you use a list-based approach, research indicates some other research is also proposing to have that more dynamic. Now, we've seen in the 2024 proposal to revise the European inbound investment screening mechanisms proposed by the Commission, for instance, that they were trying to adopt a much more dynamic approach in Annex 2 of the proposal. However, that got really stricken down by the member states in the council proposal that followed right after, very much pushing back against this notion of dynamic lists that then translate into national member states' restrictions. There are other things that we can talk about, but let's keep that for the discussion. Basically, the takeaway that I just want you to have is there's this sort of mismatch between at least partially the technological advancements and this notion of technological leakage that we might want to look into further for our economic security policies. Thank you so much.
Okay. So my paper is based on something that my friend Wei Huan and I wrote for the World Trade Review, which will be published soon. I wish I could invite Wei Huan to come here and present together with me, but apparently there's a rule at SIEL conferences where he cannot appear in two panels, so I have to do the presentation today. But if you have questions later, you can direct them, especially the hard questions, to Wei Huan. Okay. So let me start by asking you a very simple question: can trade wars be good? Anybody? Any reaction? Yes or no? Yes or no? Okay. Yes or no? Yes. How about the rest? The silent majority has not spoken, but I feel a resounding no from the audience, right? Because you even refuse to engage with this question. But according to the most cited authority on trade law these days, trade wars are not only good, but easy to win, right? And that person apparently is Donald Trump, right? I think everybody cite him these days, so making him the most cited person in trade law. Well, I think most of you would probably disagree with him, but I think he has a point, because why did he launch the trade war in his first term against China and a few other countries, and in his second term against the whole world? Because apparently he identified a few problems in the current multilateral trading system. So we are all familiar with these rules in the WTO, right? First, the consensus rule, right? Which means that every WTO member could potentially block a deal in the WTO. And this is actually why, even though now 24 years after the launch of the Doha round, we are not making any progress so far, even though we have negotiated all these trilateral deals like GSR on e-commerce, on investment facilitation for development, and on domestic regulation for services and so on. But several of them has been blocked by certain countries, India and South Africa in particular, into incorporating in the WTO. Second, the MFN rule, which is regarded as the fundamental principle in the WTO, but the MFN means that any commitment you make to one WTO member would need to be multilateralized, would need to be offered to everyone else, which kind of explains why we have not seen a major reduction in tariffs in the WTO, but all these countries, including India and South Africa, which has been blocking progress in the WTO, but are happily making commitments in free trade agreements, right? Exactly because they don't have to offer to the whole WTO membership in these FTAs. Another problem is the non-tariff barriers, or the NTBs. Well, the WTO has rules on these, right? The TPT agreement, SPS agreement, and so on. But the problem is that, to be able to discipline these NTBs, you would need to distinguish between those which are premised on protectionist intent versus those which are based on true public interest, right? And that is very hard to do in the WTO. Another principle in the WTO is the secret single undertaking principle, which means that nothing is agreed until everything is agreed. But so far, this has caused a lot of problem in the WTO, because countries frequently try to link different issues. So even if they do not have an interest on a specific issue, they would hold off making commitment on that particular issue because they want to use it as a leverage to pressure other countries on another issue. So if you look at the WTO's history so far, for the past 30 years, basically, all of these agreements that you reach in the WTO are all actually single issue agreements, right? If you look at, for example, the trade facilitation agreement, right, the ITA, right, the government procurement agreement, and all these GSIs, the e-commerce, investment facilitation, they are all single issues. So that means that the single undertaking probably is not working. Another problem is the special and differential treatment for developing countries. Well, it used to be okay, right, in the 60s and 70s when the enabling clause, for example, and part 4 of the GATT was first introduced. But nowadays, if you look at the largest economies in the world, among the 10 largest economies, actually, at least 3, right? China, India, and Brazil are the so-called development countries. So can they continue to enjoy the special and differential treatment? That is a big question. And last but not least, the WTO, we could argue, focus heavily on production or export, but it really does not do much regarding employment and consumption. And that was not the original plan, because if you look at the original Harvard Charter, as you can see, actually, in the first 2 articles of the Harvard Charter, they explicitly mention the key role of consumption, of demand, and employment, right? They recognize that the economy actually does not just run just based on production or exports. You would need people to buy this product, to consume these products. And to do that, you would need the workers to earn some decent wage, right? So that they can buy these products. But unfortunately, the Havana Charter was never adopted. And also the emphasis on consumption and employment was largely forgotten during the Cold War. Why? Because during the Cold War, the GATT was only for capitalist countries. The GATT was the capitalist club, and the communist countries are not participating in the GATT for most of the time. And the communist countries actually have another organization, the COMCON, right, which take care of the trade among communist countries. So if you look at the competition between the 2 blocks, the communist bloc versus the capitalist bloc, the only way that they can measure who wins the competition is by focusing, instead of consumption, is by focus on outputs, right, on production, right? So that is why everybody, single-mindedly focus on production. So that is not really healthy. So in this sense, we could argue that actually the comparative advantage, actually Trump's trade war could be good, because even though, I think numerous articles has been written about how it violates the key WTO principles, especially the MFN principle and the tariff banning principle. But at the same time, if you think about the liberation trade tariff, it does reveal deeper problems within the theoretical, theoretical foundations of a free trade, especially the theory of comparative advantage. We are not all familiar with the theory of a comparative advantage, right? So David Ricardo will talk about, wine and clothes production in UK and Portugal. But there is some underlying implicit assumptions which he didn't mention. The underlying assumption is that the 2 countries need to have, similar institutions, and also their differences would be natural rather than because of some external policies. But if you look at the reality we are in today, that is not the case, because many countries now create artificial advantages through things such as subsidies, lax standards, and so on. And also their institutions are different. Imagine, in the original example, if, Portugal pays its workers really just a minimum wage, or let's say if Portugal, uses slave labor, right? So for slaves, you don't need to pay them any salary, right? You just make sure that they don't die, right? And they work, all the time, right? And then even though they export a lot of wine to the UK, there's no way that the UK can export the clothes back, because they don't need the clothes, right? Okay, they don't have money to buy the clothes. So that is where the current system is not working, and that is why Trump's trade war could provide a corrective mechanism. And as we argued in our paper, they can basically neutralize distorted comparative advantage and force the non-market economies to internalize the cost so as to create a new equilibrium. And this could also provide systemic fixes to the problems I mentioned earlier. First of all, there will no longer be a deadlock because of consensus, because now all deals are bilateral. And second, you don't need to worry about MFN constraint because the concessions are also bilateral. And as to the NTBs, they can be addressed with tailored mutual recognition agreements like the one I think US is negotiating with UK and so on. And also the problem with the single undertaking is gone because now you can pick the issues you are most interested in. And SDT is also irrelevant because if you have a bilateral deal, either you enter the negotiation or you don't. So it doesn't matter whether you are a development country or not. And it also helps with enforcement because we can use real-time tools such as supply chain auditing tools to deal with these problems. And you no longer need to worry about the collapse of the dispute settlement system in the WTO because all these are bilateral deals. So to conclude, I would say that trade wars probably aren't good, but they can be useful in the sense that they can spur reform, much needed reform in the multilateral trading system. At the same time, the bilateral deals pursued by the Trump administration does risk fragmentation and marginalize weaker, smaller economies. So instead of bilateral deals, I would propose plurilateral deals. We think that this would provide a promising middle path. And as I mentioned, indeed, if you look at the history of the WTO itself over the past 30 years, all deals essentially are issue-specific plurilateral deals, most of the deals. Like nowadays we have e-commerce and MPIA. So we argue that the US tariffs should not be the end goal. It should be the leverage, okay, to achieve possibly a WTO 2.0 that would reflect the realities of divergent economic systems. So to conclude, we are sorry that the egg is broken, but you can't make an omelette without breaking the egg. Thank you.
Well, thank you to our panelists for their insightful commentaries. Well, the sort of preliminary conclusion is that whether we're talking about global wars in the global context, or we're talking about critical raw materials in certain regions, or we're talking about even more domestic food security issues, or European attempts to transfer technology, there's one thing clear, which is that international economic law is being stretched in a direction that is making the rule book no longer sufficient or in certain cases relevant. I'm inviting now the audience to think about a few questions to raise to the speakers. And in the meanwhile, I'll be kicking off this Q&A session with some questions I've already thought of. I'm going to begin with them, and I'm going to give our speakers rather short time for answering them, and probably we're going to also have some questions from the audience. The first question I have to Diana, it was very interesting to hear, to hear your perspective about the investment treaties, and you mentioned that there is this expropriation approach that is currently being used, or is being planned to be used overall. But I'm genuinely, interested to know whether there are other types of measures that you've come across in your research that might be implemented in investment treaties, such as small-scale farming or sustainable land use, or any type of measures other than, the traditional expropriation approach. And I would also like you to sort of touch base, if you can, on whether the Latin American states overall are making effective use of the flexibilities that the trade law allows, such as, Article 20 exceptions, but not necessarily limited to it. especially given the context of COVID-19. And if you can, address this issue, that would be very, very useful. For Natália, I thought about something rather, elephant in the room again, but so you highlighted some consuming countries being at the forefront, dominating the current governance arrangements. But what I am curious about is what role could a South-to-South alliance can play in this? Do you see any concrete moves to that direction in the regional level? And whether the other global structures such as WTO or we have UNCTAD, for instance, are they adequately responding to the strategic role of critical minerals and raw materials in general? Do you think there must be, or shall we create a critical minerals exception? So that's the question that I wanted to raise to you. For Tim, I would like to ask, because he described a puzzle, right? And the puzzle is very striking. We see that developed states once exported their technologies, and now this is completely reversing. That's what he explained to us. For instance, now we see that e-vehicles or batteries being to the contrary. So 2019 FDI regulation and all these recent developments at the EU level, the instruments. What's your take on whether this why your narrative is proving persistent despite all the European approaches being taken so far? I would also like to ask him whether the current screening rules in Europe, in his view, are rigid, so to say, not to allow a proper or modernized, let's say, approach for mutual tech exchange, such as in the case of Huawei. And finally, for Henry, I liked his ideas, and I want to expand the question to also to the audience, because that's a very interesting topic that we can all discuss about. So I was wondering, because your focus was mostly on how the current WTO rules are affecting or not balancing the needs of today, but I've not heard a lot about how would this proposed amendments affect the smaller or rather less powerful economies. So my question is, how could a reimagined multilateralism, according to your approach or opinion, would make sure that it would also protect their voices and interests? And another question that I thought of is, if, as you suggest, trade wars can act as a corrective mechanism, how should international law evolve to that direction to distinguish between strategic correction, like the one that you suggest, and economic coercion that is at the forefront of today's topics? Thank you very much.
Okay, regarding the first question about expropriation, the thing is that you can see phenomena in Latin America that they don't it's an indirect expropriation, right? So the example that I presented was an expropriation. The action was a direct expropriation, but you can find other type of policies that are indirect. So the effect that it has is that at the end of the day, states face precisely the threat of an investment tribunal, and all the discussion on whether on what is the scope of the treaties regarding investment. Probably some of the discussions that also I have found, but not something to highlight or not so relevant, are related with fair and equitable treatment, of course. However, I would say that the most important is that we always see expropriatory measures because we are always talking about land, right? Regarding the second question on whether there are the flexibilities in trade, they have been used, but I don't think states have managed to be effective about it. And a good example of that, it's a recent dispute that it was not a WTO dispute, but it was between the United States and Mexico regarding corn in the context of the UMSCA. Because the argument of Mexico was very interesting. They say corn is vital. So they established the argument regarding morals, what we can say Article 28, but it's in the UMSCA, I don't remember which is the provision. And the argument said it was moral, but it was culturally relevant for them. So the protection of corn in comparison with what happens with transgenic corn was based on this. And the conclusion of the tribunal in that case, because it's the trade tribunal of the UMSCA, was no, we don't agree with you because we don't think this is a moral question. From my perspective, I think it was a very innovative argument because indeed, if you look at the history of Mexico, for them, corn is vital. And there is a reason why the protection of corn with genetically modifying corn has to be done. But that's the problem that the states face right now. So in the case of, for instance, Peru with the potatoes, what is going to happen with transgenic potatoes for the matters of trade? We haven't go there, we haven't been there yet, but it's a discussion that it's about to be open. So in general, and to answer both of your questions, the thing is that probably states, and this is also on the way in which the system is constructed, they are challenged on how they are going to defend this particular interest and of national security, like it's food. But it's not that easy because the standards are way too high, even if you're in trade or in investment, under the investment scope. Thank you.
Thank you, Ugur, for your questions. Regarding South-to-South cooperation, I believe it's key because we actually have a problem of lack of bargaining powers if countries negotiate individually, and we need to shift that balance through collective action. Regarding Latin American initiatives of South-to-South cooperation, there has been some MOUs signed between Latin American countries, but it's very in the initial states. And back in 2023, we had news that Bolivia, Chile, Argentina, and Brazil were talking about creating a lithium group in the region based on like an OPEP model that would they would coordinate economic variables, but also other things like it would be a group to improve the development of battery industry in the region, and also probably developing the market for electric and hybrid vehicle. But that's really now at the aspirational stage, because that was before the election of Milei in Argentina, and now there is a lot of political misalignment in the region. So this we haven't heard about this the creation of this lithium group again, unfortunately, because collective action is really important. And regarding your question, if the global governance is failing in addressing critical minerals, I think that we cannot blame right now the global governance, because we're really in a transitional moment right now. As I mentioned, that concept of regime complex as articulated by Nidhi Shrivastava, she has a research that tells us that more than 140 institutions globally, considering like international organization, mining forums, private initiatives, they are discussing critical minerals. So it's really a dense web of institutions trying to address the issue, and we are just in a transitional moment, and we're trying to accommodate the interests of everybody. And that's why I don't think that creating more exceptions regarding critical minerals is a good idea right now. From the perspective of developing countries, it's interesting to actually clarify better the policy space they have to add value to the supply chains and have environmental safeguards, for instance, but I would not create more and more exceptions because that just weakens the multilateral systems. So thank you.
From my side as well for the questions. So first, why is the European approach proving to be so sticky? Let me just try to answer that with a small anecdote. I was recently having lunch with one of the persons who I've worked with in my traineeship. And as you might know, each sub-part of the European Commission, the DG, the Director Generals, they all have an abbreviation. Like DG Agriculture is called DG Agri, the DG for Internal Market is just called DG Grow. And trade used to be always just called trade. But as you might know, with the new commission, the DG Trade got renamed into DG Trade and Economic Security. So I was asking him, you know, how is your new abbreviation? Because it can't be more than 5 letters. And he was telling me, you know, Tim, well, we just reinterpret the E at the end to refer to economic security. And I think this is a little bit reflective of the notion, the ambivalence of whether or not this kind of change has really sunken in everyone. And it's not just an anecdote. I mean, if you look at Maroš Šefčovič's June 2025 speech at the Brussels Economic Security Forum, he was saying that, yes, we are witnessing a profound paradigm shift, but what's his answer to that? Well, we are here to improve the system, not bend it to the point of breaking. We're certainly not abandoning it. Trade is progress, trade is peace in motion, and therefore we are doubling down. And so I'm not sure if that is really reflective of a real new vision on that. And just briefly on the second point, between how flexible is the approaches. As I was saying, there's attempts to make them more flexible, but at the same time, at the moment, we also see quite a bit of experimentation happening in each of the different member states' legislations, and it can be good and bad at the same time. Bad because it's not harmonized, good because you have more flexibility and just things to try out at a time where we're not really sure what the right answer is. So ambivalent.
Thank you, Ugur, for the question. So first, the question on the difference between strategic correction and economic coercion. I think it can be differentiated in 2 ways. First of all, if you use tariffs and other trade measures to try to achieve non-economic goals, such as political and so on, I think that is typically economic coercion. But if you use it to address economic issues, then I would say there's probably more like strategic correction or recalibration. And second, it depends on whether you are destructive only or constructive as well, right? If you just want to destroy the old system without offering anything new, then that would be coercion. But if you try to propose an alternative framework, then I would call that strategic correction. Now, second question is on the implications for smaller economies. There's a saying in my part of the world, which is when elephants fight, who hurts the most? It's not the elephants, right? Because they are big animals. It's the grass beneath them, right? Okay, so the grass are the smaller countries, okay? But at the same time, when elephants mate, who hurts most? It's also the grass. So the smaller countries are doomed, regardless of the relationship between the major powers, okay? But I think the good news is that, if you have some sort of rules-based system where things are working according to what it should be, then things would be much easier for the smaller economies. If you look at China's trajectory of growth, for example, I mean, China for the first half of its 50-year reform and economic reform and opening up policy, for example, has been largely following the trajectory of its East Asian neighbors like Japan, Korea, right, and Taiwan, where the economy develops, they move up the value chain, and the people get richer and richer, right? So the expectation is that they will start buying more foreign imported products, right, like from US and EU and so on. But if you look at what happened in the second half, that didn't happen. Instead, China reversed, as I argued in my book, again, co-authored with Wei Huan, from a market economy, between market economy and state capitalism. The first part of the reform was really China moving towards market economy, but in the second part, they went back towards the state capitalism. So because of the state capitalism, so actually the real wages of the workers have not increased. Instead, if you compare the wage of the workers in China today with that of the 90s, it has declined if you, adjust for inflation and so on. So that explains why, 5 years ago, the Chinese government introduced the so-called dual circulation strategy, tried to push for more consumption. It has not happened even after the Chinese government trying very hard for the past 5 years. So that is why, we are having this tectonic shift in the world economy now because of the imbalance between US and China. China last year had a trade surplus of $1 trillion, which is the largest any country ever recorded in the whole history of the world. And that cannot sustain, So I think, in a way, if the trade war can, kind of force China to focus more on domestic consumption to increase the wages of the people, then that could be good news, not only for the US, for China, but also for everybody else, including the smaller economy as well, because that means that everybody would have more opportunity to export to China, right? And that would help to remove the economic imbalances and make the global system more, equitable. Thank you.
Thank you very much, Henry, and thank you very much for all the panelists for answering the questions. Now I'm inviting if there's anybody else. Oh, we have so many questions. Okay, let's start with you. Would you like to? Yeah.
1, 2, yeah. Good afternoon, everybody. My name is Nisha McDonough. I'm from the School of Business and Law in Perth. Question for Henry and Wei Huan. May want to weigh in on this. I hope it's going to be a hard one, Henry. So we'll see. That concept of artificial advantage, I thought was very interesting. That batteries on the way out. Yeah, so the concept of artificial advantage. Oh, I've got through a lot of microphones. Maybe I'll do it without. I'll do it without, will I?
You can use this.
Yeah, have we got power? Okay. Yeah, okay, I'll try again, Henry. Yeah, so artificial advantage, that's a very interesting concept, and I think a very problematic concept in many ways. If we're kind of comparing that to comparative advantage in Ricardo's kind of time, and we're saying there's natural advantages and unnatural advantages, in a modern economy, I mean, everything's socially constructed once you go past basic technology, once you go past agriculture or hunter-gathering even, right? You start getting into socially constructed advantages. So let's just take lax standards, for example, right? Ricardo's time had no standards. Kids were working in factories, pollution was dumped wherever, right? And so standards developed over time at different rates in different countries due to political processes, social contestation, etc. And so, and if we bring that up to current days, right, we think about rare earth elements, incredibly dirty process. Countries all over the world were very happy for China to take on that pollution and keep those lax standards. They didn't want anything to do with it. It's only become, those standards are only contested now, mainly because of security issues, and they're going to use standards to start kind of saying, well, we don't want to buy that product from China because it's too dirty, and that those standards aren't the same as our standards. But again, that's a socially constructed standard. It's not unnatural, it's not natural, it's socially constructed. So if we're being problematic, again, suppressed wages, Germany has suppressed wages compared to France or the UK. They've lower consumption, they've corporate wage bargaining and a productivist model. So who can say suppressed wages is artificial, right? It's only within dialogue that between countries you might say, we don't like that standard anymore. Do you want to raise it? So I'm just wondering, like, how do you think about artificial advantages, subsidies in the WTO? Again, it's by agreement whether they're good or bad. And would socially constructed advantage be better? Because I think otherwise you're going into a very deep pit of problematization that everyone can challenge and say, well, what's your basis for saying this is artificial and what's natural in contrast?
Maybe we'll click all the questions.
Oh, yeah. Here we go.
Hello. Sorry, Maui. I take the question first. So I'm Jeffrey Lowe from King's College London. Also a question for Professor Henry Gao and another question for all the panelists. An observation that China and the United States has a serious imbalance, in my opinion, only reflects a partial picture. If we also look into the financial accounts, you will see that there's a capital infusion into the United States from China. So the world is not only connected. The countries is not only connected with each other by international trade. This is not 19th century. So we are also connected by the enormous capital market. So there is a problem. Yes, in this way, it's not sustainable. Yes, but it's not. Unfair in the sense that China is taking advantage of the United States only because of the trade imbalance. And my second question to all the panelists is that if we still subscribe to the idea that free movement of goods and capital is good for the world in an efficiency sense, then where do we draw the line for this movement towards security? Let me give you an example. That recently in the newer investment treaties, for example, like the U.S. Colombia trade promotion agreement, the security exceptions were added a footnote, basically saying that the host state can raise the security exceptions, and the tribunal have to accept that. So essentially means that, borrowing the term from the claimant in that case, that essentially the host state is getting a free out of jail card, meaning that they can decide what is security and when they want to use it, and the tribunal have no say on that. So if that's the case, it begs the question whether the investment agreements are reduced to a mere sort of a de facto soft law instrument. Yeah, is that what really we want? Thank you.
Thank you very much. I'm going to collect two more questions, but perhaps any questions on investment screening or, okay, here we go.
First of all, thank you, Henry, for doing a fantastic presentation for us. Obviously, it's made a very good choice not letting me to do the presentation. I don't want to take the time from the speakers, so I think Henry answered that question. What I can do is not to ask Henry a question. The question to Tim very specifically. We know how the criticism about technology transfer has been targeted at China for a long, long time. Through the investment screening process, implicitly or explicitly. My question to you is, because China has caught up, basically the ladder of technology advancement, and especially, for example, electric vehicles, new energies, and AIs nowadays, as you mentioned. Have you observed any trends in Europe and in other countries' economies that are using the same kind of screening process to ask Chinese companies to transfer technology in investment?
One last question, Marcus.
Thanks, Marcus Gustafsson from and Economic Security. Maybe can I not use the mic?
All right. Thank you very much for the questions. If you would like to answer here, feel free to.
Thank you for all of the questions. I will just answer the two directly specific to me and happy to discuss more in the discussion and later on. So first, does Europe want tech transfer back from China now, basically? And yeah, we have seen, so I think that there's a mix between efforts more looking at that companies want to collaborate more, and that's why they might be more worried about something like outbound investment to partially learn from, for instance, on AI, working with Chinese companies. But on the other side, also, I think I'm under the impression that there seems to be an emphasis also on the creation of domestic capabilities, just out of your own ground, that this might lead to more technological sovereignty, even if you're not just learning from the other person, from the other companies, but creating this kind of knowledge locally, in a sense. And very briefly to Marcus's question, does with China's strategy on technological acquisition, does that leave Europe blank in a sense? And then for the first question I would ask is, what is this then really about? Is it about economic competition, that you try to restrict certain technology transfers, or is it about leakage of certain very unique, maybe military-related technologies? And the answer of how to approach it then would, I think, be different. And if it's the latter, then I would emphasize focusing more on the international technology transfer literature. And there's, for instance, a great paper from 2015 from Ian Stewart, which talks about the different models of capability acquisition. And he says that it's not inevitable that domestic capabilities are always created. What's relevant is focusing also on tacit knowledge, not just explicit knowledge. He draws on Michael Polanyi to have like this big argument he makes. And there, I think the emphasis would be, what about actually the movement of individual people, researchers? And that, for instance, has been now kicked out of the outbound recommendation in comparison to the white book.
Thank you very much for everyone. I think we're ahead of our time, but I just wanted to ask finally whether Diana or Natália has anything to add. If you guys... Okay, perfect. Thank you very much for participating. I hope it was a good and fruitful panel. See you in the other ones.